purpose of the Visa Waiver Program is to visit. It's to stay in the hotels, go to the theme parks, go to Las Vegas, spend your money, and go home. That's what that's for. The Visa Waiver Program has very specific restrictions on it. First, it's for 90 days. It's a lockdown visa where the B visitor visa is generally for 6 months, or it can be shorter at the discretion of the officer. But the idea of the Visa Waiver Program, it was created to allow people easy access to the U.S. on the condition that they go home. In fact, before you board the plane and come to the U.S., you have to sign what's called an ESTA form. The ESTA form, if you read it carefully, there's a statement in there that says that you waive your rights. So that makes things very difficult for you if you come into the U.S. and you misuse the Visa Waiver Program as a means of immigrating. It gives a lot more power to an immigration officer to decide whether or not you're going to stay or whether they can kick you out. And if they do kick you out, are there any penalties? Most people believe that when they come to the U.S. with good intentions, that they use the Visa Waiver Program, that they want to marry and remain in the U.S. and apply for a green card, are doing the right thing. They don't see that they're violating the laws or committing any misrepresentation until you consider the basis for entering the U.S. and how the U.S. government sees it. The Visa Waiver Program is a privilege that's given to about 26 or 27 different countries to allow them to come in visa-free on the condition that they leave. And the idea of staying and applying for a green card, by definition, is immigration. It's not a visit. And so there's the rub. When you arrive at an immigration border check, the immigration officer will always ask you what's the purpose of travel. Now, in this case, Margaret has a big wedding planned. She's got family coming. And so the purpose of travel is to get married and then perhaps apply for a green card. And when you tell the immigration officer this, that doesn't sound like a visit. There's a risk of an overstay. There's a risk that the person might not leave and return to the UK within 90 days of their arrival. And so that's good cause for the immigration officer to block entry and not allow the foreigner to come to the U.S. About 3 times a year or so, I get calls from families from the UK that are in a panic because everybody on the wedding party could make it into the U.S., but the bride or the groom is held back and they can't get on the plane, or they can't clear inspection when they arrive in the U.S. And this is a travesty. So good planning in advance is super important, especially when you have a big wedding. So when you're talking to an immigration officer, it's really important that you be open and honest about your intentions, and let the immigration officer decide what they want to do with the case. You know, it could be that you tell the immigration officer that you're coming here, that you want to get married and stay and get a green card, and the immigration officer says, okay, welcome to the U.S. But that's not their training. Their training is to block entry, and that's what they'll do in most cases. So I think if you've got a wedding planned, that you don't want to take the chance that the bride or the groom's not going to be able to make it into the U.S. and make it to their wedding. So in this situation, a call to an immigration attorney or coming up with a sensible plan in advance as part of wedding preparation is important. The other thing is, let's suppose that the foreigner does come to the U.S. on the Visa Waiver Program, gets married as planned, and then stays in the U.S. and applies for a green card. Well, there's another opportunity for an immigration officer at a green card interview to check the entry documents, see what the foreigner said coming in, and then challenge you at the green card interview whether or not you're actually telling the truth to the immigration officer upon arrival. If the immigration officer feels that you weren't telling the truth, then there's an allegation of fraud. And then again, you've got that ESTA form that you signed that waives your rights, and an immigration officer can put you in a position where you feel like you want to fight, you want to go on appeal, that you were telling the truth, that you weren't misrepresenting yourself to an immigration officer upon arrival. But sometimes you get an immigration officer who really doesn't care. So the question then becomes, how do I enter the U.S., be open and honest, but not misrepresent myself? Well, first of all, you get the proper visa, which is the fiancé visa. But let's say for a moment you want to use the Visa Waiver Program as a way of coming into the U.S. and marrying in Ohio. Your obligation is to be open and honest with an immigration officer. Your obligation is not to volunteer information, but it is to tell the truth. And so what you have to do is you have to wait and see what the immigration officer asks of you, and you have to be open and honest in your answers and not try to derail a conversation. You don't want to cut off the line of inquiry to an immigration officer. If the officer wants to ask, you simply have to answer and see if you're going to be allowed entry. That's it. Now, let's suppose that for whatever reason the immigration officer does allow you entry, or doesn't ask the right questions, or doesn't ask any questions at all, but just simply waves you through. All right, well, in that situation, it can be possible for you to go ahead and get married and apply for your green card, because you were open, honest, you represented yourself correctly, and an immigration officer allowed you to enter. Let's take another scenario, just to show you what the risks are. If you go to an immigration officer and you report that you're here to get married and that you want to apply for a green card, what could the immigration officer do? Well, you're open and honest, you haven't committed misrepresentation, so that part's okay. However, you don't have the right documentation for immigrating to the U.S. You only have the right documentation for a visit. In this situation, a friendly border agent will say, I'm sorry, we're not going to allow you entry, go back and apply for a fiancé visa. One of the more difficult immigration officers, or one that's unfriendly, or one that's strictly following the rules, is going to say, you know what, you have an obligation to appear before an immigration officer at a port of entry with proper documentation. You know that you don't have proper documentation because you only have the visa form, the visa waiver form, and really what you're doing is trying to immigrate. So I charge you with failing to present yourself to a U.S. immigration inspection officer with proper documentation. And that's actually grounds for what's called summary deportation. When you don't have proper documentation and you present yourself to an immigration officer knowingly, then you could be summarily deported. I think that's an abuse of power for an immigration officer to do it. I've seen it done many times, and a summary deportation results in a 5-year bar from the U.S. So you want to be real careful when you're trying to enter the U.S. on the Visa Waiver Program as a means of getting married, especially if you have the intention to stay in the U.S. and apply for your green card. Okay, well, what happens if you want to come to the U.S., get married in Ohio, and then go back to the U.K. with your family and live there? That doesn't have anything to do with U.S. immigration because you don't intend to stay. Marriage is according to state law. You can marry in Ohio. There's no problem doing that as long as you intend to leave after the wedding's over. All right, well, then what problem do you have? Well, the only problem you have at that point is convincing an immigration border agent that your intentions are really to return to the UK after the marriage. As far as the immigration officer is concerned, if there's a risk that you may overstay your welcome and want to remain in the U.S. after the marriage, just given that risk alone, that's grounds for blocking your entry and not allowing you to come into the U.S. So even if you do not have the intent to immigrate, but really do have the intent to marry in the United States, in Ohio or wherever, and then go back to the UK, you have a tough time convincing an immigration officer that it's okay to allow you to enter, because you have to have quite a lot of substantial evidence to show those intentions to depart the U.S. on time. Inherently, because you're marrying a U.S. citizen, there's an inherent risk that you may overstay your welcome and try to get a green card. Now, it does happen for those of you that are already in the U.S. who are watching this video, who've entered cleanly and didn't have any intention to marry when you came in on the Visa Waiver Program, that you do want to get married and you want to try to see if there's a way for you to get your green card. So no misrepresentation, it was an innocent entry, and yet you're here and you would like to get married and get a green card. Well, in that situation, there's a couple things to keep in mind. Number one is if you've already gone over your 90-day stay, be very careful, because now you're out of status and you're unlawfully present in the U.S. after overstaying on your Visa Waiver Program. You really, really, really need to call an immigration attorney with some experience and find out what are your options and is it safe for you to stay and try to apply for your green card. For those that are still in status, well, there's always going to be a question of whether you might have misrepresented yourself at the border, and you get into a pickle at your green card interview trying to get an immigration officer to side with you. And if you have a friendly immigration officer, you can stay and apply to change status and get a green card based on marriage. But if you have an unfriendly immigration officer, you're going to run into some trouble. There are some defenses out there about your manner of entry and whether you've misrepresented in fact, or whether you've waived all of your rights under the ESTA form. There are some arguments that there are some rights that you haven't yet waived and some things that you can do. But in this situation where you've entered on the Visa Waiver Program and you're trying to change your status stateside and go for a green card interview, I think it's a good idea to at least call an immigration attorney and find out details about your particular case, because everybody's case is different. They're not all the same. We just have to pick through issues with you. Thank you.